Hello, everyone. Today we have with us Mr. Vyapak Desai, who is going to share his insights on the institutionalization of dispute adjudication boards in India. Mr. Vyapak Desai is currently a counsel and arbitrator at Vyapak Desai Law Chambers, a position that he has held since August 2025. Prior to this, he was the head of the International Disputes and Investigations practice at Nishit Desai Associates from June 2005 to July 2025, that is, for over 20 years. Additionally, Mr. Desai holds various positions in the industry. He is the co chair of the Society of Construction Law Mumbai chapter, vice president of the Arbitration Bar India, co chair of the Counsel at Mumbai Center for International Arbitration, that is MCIA, a fellow Chartered Institute of Arbitrators, as well as a registered foreign lawyer with the Singapore International Commercial Court and Dubai International Financial Center. With this, we invite Mr. Vyapak Desai to join us for the podcast today. We're extremely grateful to have you with us here today.
Thanks,
So, sir,
Alisha, for the invite.
thank you, sir. So, to begin today's session, for the benefit of our listeners who may be unfamiliar with the topic, could you briefly explain what a dispute adjudication board is and why is it particularly relevant for the construction disputes?
Sure. So I think, again, thank you for the invite and Alisha and the Dhirubhai Ambani University. And this discussions came about in the interactive session which Dhirubhai Ambani University held between the academia and the industry. And everyone was, talking about the problems that the infrastructure and construction industry is facing, particularly in reference to resolution of disputes. Now, just to understand the magnitude, right? Few months back, there was a report that just the NHAI, which is the National Highway Authorities of India, which primarily does road projects, are facing claims in the north of 1 lakh crores. Now you can imagine the amount which is stuck in this kind of projects, and unless you unlock this cash flow, uh, not only the existing projects get affected, but the new projects don't start coming in. Contractors don't get money. They don't have cash flow to bid for another project, and the system is then plagued by the delays and disruptions so far as the project implementation is concerned. So what is unique about construction and infrastructure projects? Unlike any other industry where you enter into a contract and you execute the contract, there is not much which affects what was taken as an obligation and what was taken as a right at the start and at the end of the contract, because that's pretty much complete at the start of the agreement itself. But in a construction and infrastructure project, right from day one, there are variations to the project itself. There are external and internal factors which changes the cost structure. There are escalations to the costs. There are variations, or there are extensions of time required because of unseen circumstances, or sometimes seen but not calculated at the start of the project. So the nature of the industry is such that there will be extension of time for the project, variation in the contract, or variation in the employer's requirement for the project, and resultant escalation to the cost. Now all of this cannot wait till end of the project, because then it gets very complicated. It only compounds and it gets entangled in many other issues, rather than dealing with it at the time when it arises during the continuation of the project. That's where DAB, or Dispute Adjudication Board, comes in. It has different names in different context, but at the end of the day, in simple terms, it basically means that please resolve your issues before it becomes a dispute. through a DAB process on an ongoing basis, right from the start of the project till end of the project. And if some issues remain unresolved, of course, those disputes can be dealt with at an appropriate forum at an appropriate stage, right? So I think in simplest term, it is basically making sure that issues that arise during the continuation of the project do not become disputes. While the name suggests Dispute Adjudication Board, but basically I would put it in a way that those issues are resolved much in advance at the time those issues arise rather than wait till end and complicate them.
Certainly, and I think that is very important from the perspective of the fact that the project remains ongoing and is not stalled because of these minute disputes which can be addressed by a adjudication board. So I think that is something that one should be certainly mindful about. So, in your experience, what systematic gaps in India's dispute resolution ecosystem make a strong case for institutionalized dispute adjudication board frameworks?
Sure. So I think to understand that, let me take a little explanation to understand what is the dispute resolution framework as available today, particularly for infrastructure and construction projects. One, everybody knows we have courts, right? So if there is nothing, there is a court, and so you have the litigation system at your disposal all the time when you are in trouble. Second, there is something called alternate dispute resolution mechanisms, or alternate dispute resolution processes, ADR, which basically are the arbitration and conciliation or mediation, where India has done tremendously well right from 1996 when they adopted the unicitral model, and then in 2015 when the act was overhauled to bring in statutory limits to the arbitration mechanism for completing the arbitration. The process for enforcement was narrowed down and streamlined to make sure that arbitration runs in the way and the manner it was originally envisaged under 1996. Thereafter, the legislature, in its right mind frame and right wisdom, also brought about changes to Specific Relief Act, where specific performance became a norm rather than a discretion. And in fact, infrastructure projects were carved out from granting of any injunction which stalls the project. So I think the emphasis on construction infrastructure as an industry and enforcement of contracts, ease of doing business, connected to enforcement mechanisms in India was very much the priority of this government, and they have done enough to make sure we have robust legal systems and legislations to support that. Unfortunately, it has still not addressed the concerns which large infrastructure and construction projects need for the purpose of resolution of their ongoing disputes. So there has been a little bit of backtracking, little bit of rethinking on what can be the dispute resolution mechanisms. And in that light, government, finance department, and thereafter the road and transport ministry came about with a circular in 2023, 2024, and very recently as well, to say that look, for all the projects above a certain threshold, I think it's about 10 crores and odd, will not go to arbitrations, but they will either go to mediation and then go to courts. Now, the problem with all of this is we are not addressing what is the issue, why arbitrations are not able to address the concerns, particularly in this sector, is because the issues that arise during the pendency of the project needs to be addressed at the stage on which those issues arise, rather than make it very, very complicated at the end of the project, and the whole project gets stalled or delayed, and a lot of other complications come in. For which I think NHAI, the railway boards, they have come up with many circulars and internal policies where they are adopting dispute adjudication board as a mechanism to resolve their disputes and making it mandatory before parties go to either arbitration or courts. In fact, since 60s and 70s, many countries have seen the rise of DAB usage for large infrastructure projects. FIDIC contracts have as a standard norm. ICC, the International Chamber of Commerce, have specific rules under which DAB services are provided for contractors and employers who may want to use ICC rules to resolve those disputes. So even India adopts DABs. They have contractually agreed to go through the DABs, but unfortunately, where India usually fails, and I'm not saying it with any negativity, but with a positive criticism, I think where we fail is execution, where we fail is trust, where we fail is not having confidence in the systems that we already have set for ourselves. In short, a private DAB set up under a contract, either the contractor feels it is employer heavy, or vice versa for the employer, or they feel they are biased, or they feel they don't have enough teeth, or they don't have enough capability, and so on and so forth. So I think today the systems are there, procedures are there, intention is there, but I think what lacks is the implementation, the execution of it, to make sure the decisions which come out of DAB are, one, robust, and two, final and binding, that parties are having the confidence in agreeing to those decisions rather than glossing over DAB as something, waste of time, and then ending up in courts or arbitration, which obviously we have just discussed is not something which is good enough to provide the kind of resolution which large infrastructure and construction projects require.
So thank you. So I think that really lays down the foundation for why we need the institutionalized framework of DABs. But now that we're talking more practically on this aspect, what would be your view on the essential features that should be incorporated in the institutionalized DAB rules to ensure that there is speed, there is technical competence, and also that there's fairness? So, what would the rules look like in that case?
So again, I think as we were discussing, the concern is of independence, capability, and uh, reasoned adjudication and reasoned decisions by DAB, which both the parties are able to agree to or satisfied with. And for that purpose, I think the we don't have to reinvent the wheel, as we say. There are mechanisms available in the world. There are different processes which different countries and different institutions have adopted, which obviously needs to be Indianized, or I would put it in a way that it has to be uh, you know uh, put in practice, which deals with Indian issues or Indian culture, to make sure that it again becomes more palatable for the Indian industry. So the first thing obviously is the constitution of DAB, in which ultimately the human element comes into play. And question is, how do you select, elect, or nominate the DAB members right at the start of the project, who are independent to both the parties, who are technically capable and trained, and three, who are most importantly available at a short notice, to make sure that they run the process very efficiently and effectively to provide a resolution. Because look, even today DAB processes are very quick and very short timelines. Within 28 days, one has to file a claim. Within, less than 2 months, you need to close on the, broader processes and give an award. And thereafter, if you are not satisfied, give a notice for dissatisfaction. Then wait for another 56 days, 60 days in different provisions of the contract to then go for arbitration. So it's a very tight schedule, because you need to deal with that issue immediately to make sure the whole project doesn't get affected. So we need independent, technically capable and available DAB members to make sure that they are right at the start, available to the project and the issues that are arising in the project. Two, they obviously need to be familiarized with the project, so they need to make sure that they visit the site on a regular basis. They are briefed on the background of the project, on the background of the parties involved, the expectations on both the sides, so that when the issues come up, some of those aspects which may not be written well under the contract are also taken into account. And disputes in an infrastructure construction project starts from day one. uh, like, you need to hand over the site, and I don't get me wrong, but a large part of the disputes start and stem from the very first action the employer has to take, which is hand over the site to the contractor. And you can imagine, if the dispute starts on day one, even before the project starts, then what kind of complications it can have over a period of time for concurrent delays from because of external or other internal reasons, and so on and so forth. So therefore, these two aspects, I would say, we do have best practices adopted for many different institutions and many different jurisdictions. Possibly we can make sure we do the right tweaking of those processes and bring in the next practices, as we say, for the purpose of Indian infrastructure and construction projects, so that DAB becomes more functional, more robust, and more effective, to avoid cluttering of the issues becoming disputes and then affecting the project.
So I think that really lays the groundwork on what is it that the institutional rules would look like and the things that one needs to be mindful about while drafting that. And so moving on to a more pragmatic enforcement perspective, what practical challenges do you foresee in implementing the institutional DAB mechanism in Indian construction contracts, and particularly in the public sector, because we have a lot of public sector driven construction projects?
So look, Supreme Court has said for several decades the problem of a litigant is actually starting when they get a decree in hand, right? So enforcement, even when it comes to court decrees, is not easy. So let's not trivialize this issue, or let's not worry too much about this issue, because it's there. If there is a respondent who doesn't want to adhere to something, right, that person or entity will find ways and means to not adhere to, right? But then what are the options in front of us, and which is the best enforcement mechanism, right? When it comes to courts and litigation, what you get is a decree. And as I said, Indian courts have said the problems actually start after you get a decree, rather than start at the time of the dispute. So I don't want to elaborate more on that, but we know the problems of executing a decree, in spite of the fact that all the robust litigation and court systems are available, purely from and it coming from a high court or a supreme court confirmed decrees, right? Again, enforcement is a problem. Second option is arbitration. Yes, arbitration awards are final and binding, but then that is one specific reason why people are running away from arbitration, because they feel that post arbitral award you are basically restarting the litigation the way section 34 and challenges and enforcement work. Because then you are back to the court system and people are not ready to enforce the arbitration awards. Third is your mediation and conciliation. Yes, it is a wish list for the government to mediate and conciliate. And in fact, Supreme Court, the Honorable Supreme Court, has also emphasized recently that mediation should be the preferred route of resolution in many cases. But practical realities are, unless both parties agree, mediation is of no essence. Second, for a government entity or a government body, practically to give away certain things in mediation or agree to certain claims in mediation can raise other doubts in terms of vigilance, in terms of bias, in terms of corruption, and so on and so forth. So, practically, mediations and conciliations, unfortunately, are not good enough. Though a mediated award is better enforced because both parties have agreed, but that is only subject to both parties agreeing. Now comes DAB in all of this. Now just think where enforcement of DAB becomes that much more relevant, right? I would put it this way. Of course, DAB decision is not final and binding, right? You can send a notice of dissatisfaction and that's it, right? But look at the probabilities of parties agreeing to those decisions rather than challenging those decisions. In litigations and arbitrations, you are talking about a timeline of 5 years, 10 years after the project is complete, that you want a respondent to agree and pay up the amounts, right? Why would what is the incentive of doing that? Obviously, they will keep fighting, right? Mediation and and conciliation, obviously the consent doesn't come in for various different reasons. DAB somewhere falls in middle, but more importantly, DAB is on an ongoing basis, which means parties are still executing the projects. There is an incentive for both the parties to agree and enforce the DAB decision because it is affecting both the parties if they keep disputing the DAB decision, so long as it is reasonable and justifiable, right? Three, they are in reference to smaller issues, less complicated. It can address issues without other external internal factors affecting that dispute over a long period of time, right? And parties are still in tandem and they see a lot of value in continuing with the project and agree to an extension of time, agree to an escalation of cost, pay up the amount, or agree to increase the payment as the project goes on. So there are very, very high chances and probabilities of a DAB decision getting self enforced rather than challenged, so long as you are giving a justifiable, reasonable, fair DAB and, and an independent DAB to look into the issues that both the parties are facing. Of course, there are decisions of recently of Delhi High Court which have equated DAB decisions to arbitral awards and therefore can be challenged under 34. There are decisions of Delhi High Court and other courts where if DAB decisions, no notice of dissatisfaction has been sent or challenged, then they are considered as final and binding depending upon how the contract reads. So you can actually draft your contract much better in terms of a DAB decision, equate it to a adjudication by an arbitrator in some sense, because mediator doesn't adjudicate here, at least there is an adjudication and an objective adjudication of the issues before the parties, and make that decision final and binding between the parties, subject to, of course, certain legal rights in cases where one of the parties are dissatisfied. But my strong feeling is that if you deal with issues on an ongoing basis, you are most likely to have much better sense of enforcement. It's like, cleaning the house on a daily basis versus cleaning the house at the end of the year, right? If you are cleaning it on a daily basis, it is much possibly at the end of the year the house will be still cleaned, right? And you won't have to do anything much at the end of the year or end of the project. But if you don't deal with those issues, and I'm calling it as issues and not disputes, because I would put it that an issue will become a dispute only when a dispute adjudication board is not able to make a satisfactory decision on those issues. And then, of course, the dispute resolution systems would take on. So I think there is a great chance here of institutions, even like Dhirubhai Ambani University or some other independent institutions coming together to come about a solution where, while contracts may have private DABs, but the constitution of it, appointments of it, making sure the process is followed right, and parties feel that they have got an independent, fair decision is brought about in the process. I think the institutions can make a huge difference to this crazy amount of cases which are pending largely for this industry. And this industry is obviously not growing clearly as much as it can grow because one big problem is dispute resolution.
No, I think that makes a lot of sense because I, both the parties in a construction in project or dispute, if at all it arises, will most certainly keep commercial viability at the center of all conversations. And DAB resolution through that mechanism will ensure that that commercial viability still remains the focus, as opposed to litigations and arbitrations where party then just become overtly litigious in their arguments and presentations as well. And since DABs can ensure that outcomes are provided on a timely basis while the project keeps ongoing, that commercial viability of the project as a whole sustains. And that really is a very important point for why an institutionalized perspective on the DAB framework is necessary. So also
Like
to now,
like a
yes,
small scar on the body or something that inflicts on your body. If you don't deal with it for a few days, you need to cut that body part, right? Not because initially it was that bad. It is just because you did not deal with that issue at that particular point in time when it could have been resolved,
yeah.
because it is still fresh, it is still something clean and clear. You know the diagnosis, you know the what is the surgical requirement, or what is the ailment, and therefore what is the medical issue. Same thing for the issues that come up. If you can ring fence it from the rest of the project and deal with it, then it would not affect the rest of the project, right? And we
It will
know
not
the importance.
it will not aggravate and exaggerate the claims and issues at the end of the day, of course.
And we know, right, as I said, why a specific relief act is specially calling out infrastructure projects. Obviously, because any injunction or any delay in infrastructure project can result into huge problems on cash flow, finances, economy, and generally the state of the country, right? To the projects are complicated enough, projects are complex enough, and therefore it requires that much of importance, and therefore rightly so, government is trying to find a way. Litigation, arbitration, mediation, litigation, they are obviously trying to see how this can be resolved. Question is whether that's the right approach. Maybe one can look at what happens ultimately to the unresolved issues. We are now talking about a completely new issue, which is avoiding those issues becoming very complicated disputes at the end of the project when nobody is interested in resolving those disputes because there is no incentive to do it. Rather deal with it when both the parties have incentive to deal with it. And for that, if we have to give them an independent, robust procedure which deals with those issues on a timely basis and in a fair and responsible manner, then it's a no-brainer that this is something we should work out in an Indian context.
Certainly, and I like the use of word avoidance that you use, because this is something that I always think of, the manner in which the terminology has evolved over the last several years now. Firstly, we were completely litigation centric as an industry. Then we moved towards dispute resolution because we realized that resolution is more important than just going to courts and constantly arguing. So then we became more alternative dispute resolution centric, and now if you look at the construction industry specifically, it's moving towards dispute avoidance, because that is what the need of the hour is, to get things done on time, because at the end of the day, time is money and everyone wants their projects to move as smoothly and swiftly and effectively as possible. So from a conflict avoidance perspective, something of a platform like this will certainly be of great use to the industry partners.
So if I may add, since you talked about phraseology and different ways to describe, I think you said we moved to alternate dispute resolution, and I think somebody was asking me earlier that why is ADR not successful in India? And I said, look, if you changed the words ADR uh, or 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 rephrase ADR to say it is a parallel dispute resolution mechanism or an appropriate dispute resolution mechanism rather than an alternate dispute resolution mechanism, then suddenly one would think that, oh, this is not alternate to something, right? Because alternate to something means it is subset of something or it is secondary. But if it is an appropriate dispute resolution mechanism or it is a parallel dispute resolution mechanism, then even courts would look at it from a perspective that it is not under us, but it is in parallel, where we might have to work in tandem, but it is not something that requires interference in that sense. So I think words do make a difference. It changes the mindset, and maybe it is time to uh, call it as an appropriate dispute resolution mechanism and not alternate dispute resolution mechanism, to make sure people understand that this is the right way to go.
I think in the West, they've already started doing that, and maybe it might move here too. So to wrap up with a last question on what would the future look like if institutional DAB systems are effectively adopted, how could they resolve dispute resolution and project delivery in India for, let's say, over the next decade?
Yeah, I think we have discussed that in the terms of this, discussions in last few minutes. But at the end of the day, what we are saying is, it's not like we are trying to completely overhaul or change the course in that sense. We are only trying to address an issue. We are now thinking in a way that, look, let's identify what is the issue. Issue is implementation and execution of the DAB system, and why that is not working. It is not working because it is not perceived independent, it is not perceived capable, and it is not taken seriously. So, if institutionalized DAB comes into play, like in an arbitration, ad hoc versus institution, right? I think the moment institutional arbitration came about and government laid the emphasis on institutional arbitration, a lot of things have changed for a positive side when it came to arbitrations in India. So even today, the problems that we are talking about in arbitration are less relevant for institutional arbitration, but more relevant for ad hoc arbitration. Similarly, if we can tweak the DAB implementation, not the concept by itself, by bringing in institutional DAB framework as part of our projects, and if we have robust systems to implement DAB, then it can possibly reduce the disputes to, I would say, half or even more, because a lot of them will be resolved much in advance rather than going into the routine litigation or dispute resolution mechanism. So I think it can really contribute in a big way by just making something which is more central, which is more institutional, and which is accountable to the public at large in terms of what they are doing. And obviously, transparency will come along with transparency. So I think those are the factors which will make this system very very successful. Otherwise, there is no way we can resolve these disputes by saying we'll do mediation or litigation. What are we trying to suggest? It is the same problem in a different way, right? We are never going to get the final result as part of that process.
Thank you so much, sir, for taking your valuable time out to speak to us today on this issue. We really appreciate your insights, and it was an absolute pleasure speaking to you, sir.
Thank you, Alisha, for this, and thank you again, Dhirubhai Ambani University, for holding this podcast, and hope we'll collaborate on other projects as we go along. Thank you.
Thank you, sir.